Happy day. Standing before you is Dr. Shakila P. from the Department of Accounting and Finance Shift 1 from M.O.P. Vaishnav College for Women. So let us see the contents of the contract. What do you mean by law? Nature of law of contract, jus in rem and jus in personam, flow chart for a contract, definition of contract, essential elements of a valid contract, and classification of a contract, a quick study. So meaning of law. So what is law? Law means set of rules to control and regulate the conduct of the people and to protect their property, contractual rights. So law as a general term gives different connotations to different people. So a citizen may think of law as a set of rules which he must obey, and a lawyer who practices law may think of law as a vocation. What is vocation? Vocation means it's a trained people for a particular work, and a legislator may look at law as something created by him, and a judge may think law as a guiding principles to be applied in decision making. So what we are going to see is business law, that is the rights and obligations of mercantile persons arising out of mercantile transactions. So mercantile is trade, which deals with trade. The act deals with the general principle of the law of contract from section 1 to section 75 and the special contracts from section 124 to 238. And the first 6 chapters of the Act deals with the formation of the contract, the essentials of the contract, the performance or breach or the remedies of the contract. The remaining chapters deal with some of the special contracts, namely indemnity and guarantee, section 124 to section 147, bailment and pledge, section 148 to section 181, and agency from section 182 to section 238. And law of contract creates jus in personam and jus in rem. So we will have to understand what is jus in rem and jus in personam. So jus in rem is nothing but a right against in respect of a thing is a jus in rem, and jus in personam is a right against a specific person is jus in personam. So jus in rem is available against the world at large, but jus in personam is available only against a specific person. Example, A owes a certain sum of money to B. B has a right to recover this amount from A. This right can be exercised only by B and by none else against A. So this right of B is jus in personam, only to a specific person it is allowed. X is the owner of a plot of land. He has a right to have quiet possession and enjoyment of that land against every member of the public. Similarly, every member of the public is under an obligation not to disturb X possession or enjoyment. This right of X is a jus in rem. So the right against the respect of a thing. Agreement. According to section 2E of the Indian Contract Act 1872, an agreement is defined as every promises and every set of promises forming consideration for each other. So promise is defined thus: when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. According to section 2B of the Indian Contract Act 1872, a proposal when accepted becomes a promise. So therefore, agreement, there must be a proposal or offer by one party and acceptance by the other party. To sum up, agreement equal to offer plus acceptance. Obligation. An agreement to become a contract must give rise to a legal obligation or duty. The term obligation is defined as a legal tie which imposes upon a definite person or persons the necessity of doing or abstaining from doing a definite act or acts. An agreement which gives rise to a social obligation is not a contract. Examples: A agrees to sell his car to B for rupees 50,000. The agreement gives rise to an obligation on the part of A to deliver the car to B and on the part of B to pay rupees 50,000 to A. So this agreement is a contract. So hence from A to B, there is a contract. So this agreement is a contract. In the next example, A promises to sell his car to B for rupees 50,000 received by him as the price of the car. The agreement gives rise to an obligation on the part of A to deliver the car to B. So here in this agreement is also a contract because the agreement gives rise to an obligation from A to B. So this agreement is also a contract. A invites his friend B to come and stay with him for a week. B accepts the invitation, but when he comes to A cannot accommodate him as his wife had died the day before. B cannot claim any compensation from A as the agreement is a social one. So here this is not a legal contract, it is a social one, hence it is a social agreement. A father promises to pay his son for rupees 100 every month as pocket allowance. Later, he refuses to pay. The son cannot recover as it is a domestic agreement and there is no intention on the part of the parties to create legal relations. So these are the few examples which is given to tell you that when an agreement is a contract and when it is a social agreement or a legal obligation. The flow chart to explain how a contract emerges. So it starts from offer or proposal. So there must be an offer or proposal by one party and it has to be accepted by the other party. So acceptance evolves, and then acceptance has to be from set of promises plus consideration. Consideration here is according to section 2D of the Indian Contract Act 1872 says that consideration is something in return. So set of promises plus consideration is acceptance, and then it moves on to agreement, and then agreement will evolve when consensus ad item plus offer plus acceptance is there. Consensus ad item is meeting the minds of the parties. So when one party raises the offer and the other party accepts it, they have to meet in the same mind, same sense, accept in the same sense and the same mind, and then only there is a consensus ad item. So consensus ad item plus offer plus acceptance gives you agreement. Agreement should be legal obligation. So it should not be a social agreement, it should be a legal obligation, and hence it will then move forward to contract. So contract is agreement plus enforceability by law. So any agreement which is enforceable by law is said to be a contract. So therefore contract equal to agreement plus enforceability at law. So thus all contracts are agreements, but all agreements are not contracts. So hence, according to section 2H of the Indian Contract Act 1872, it says an agreement enforceable by law is said to be a contract, and Pollock says that every agreement and promise enforceable at law is a contract. So this is a small table which tells you the essential elements of a valid contract. So it starts from offer and acceptance. So there must be an offerer and an acceptor. One party has to raise the offer and so that the other party will accept it. So offer and acceptance, and intention to create legal relationship. Yes. So social agreement do not create legal relationship. Therefore not contracts. And lawful consideration. So consideration, there must be something in return, must be real and lawful. And then capacity of parties. Parties must be of age of majority and of sound mind, of not disqualified from contracting by any law. So sound mind, he should not be an idiot or a lunatic person, he should be able to accept the same thing in the same mind. Free and genuine consent. Parties must agree on subject matter in the same sense and at the same time. So consent should not be induced by coercion, that is any threat that I would, for example, I would commit suicide. So there should not be any threat. and undue influence. From the willing of the other, you should not do something. So, undue influence, misrepresentation, fraud or mistake. It should not be from any of the things. It should be free and genuine consent should be there. Lawful objects. Objects must not be illegal. It should not be something which is illegal, immoral, opposed to public policy. And agreement not declared void must not have not been expressly declared void by any law enforced in the country. And certainty and possibility of performance. Agreement must not be vague or impossible to perform. It should be clear and legible so that it can be understood. Legal formalities. Contract preferably written must be registered or stamped as per the requirements. So, these are the 9 essential elements of a valid contract that will explain the essential elements of a valid contract. Classification of a contract, a quick study. So, what is a voidable contract? So, according to section 2I, it says a contract enforceable by law at the option of one or more of the parties to the contract, not at the option of or others. Then it is a voidable contract. Void is a contract which ceases to be enforceable by law is said to be a void contract, and valid. So, it is one which fulfills the essential elements of a valid contract is said to be a valid contract, and illegal, one which transgresses the public policy is illegal or criminal activity which involves into criminal or illegal activity is said to be the illegal contract. Unenforceable, one that cannot be enforced because of a technical defect or a lapse of time is said to be an unenforceable contract. Express contracts, a contract which the terms are stated in words, expressed, are called as an express contract. Implied or tacit contract, one inferred from the circumstances or from the conduct of parties. Implied is which is implied already. Quasi contract, obligation created by law regardless of any agreement is a quasi contract which is created by law. E-commerce, one which is entered into via the internet. Executed contract, that is contract wholly performed by both the parties are called as an executed contract. Executory contract, contract where promises by both the parties are yet to be performed, have not yet performed. So, hence it would be a executory contract. Unilateral contract, a contract in which only one party is yet to perform the obligation is unilateral contract. And bilateral contract, a contract in which both the parties are yet to perform the obligation is bilateral contract. In today's session, we just saw what is law, what is jus in rem and jus in personam, what is obligation, what is agreement, what do you mean by a contract, what are the essential elements of a valid contract, and the classifications of the contract. I hope you found the session useful. Thank you.